Although most decisions under the UDRP, the Uniform Domain Name Dispute Resolution Policy, are in English, English is not the default language for all UDRP cases. But knowing when and how to argue that a proceeding should be conducted in English, if that's what a trademark owner prefers, can be important for both time and money, as IBM obviously knew when it filed a recent complaint. Hi, it's Doug Isenberg, and the UDRP case I'm talking about today involves the domain name IBMHistory.com, which obviously contains the well-known trademark owned by International Business Machines Corporation. According to the UDRP decision, IBM traces its roots back to the 1880s and has been a leading innovator in the design and manufacture of a wide array of products, including, of course, computers and computer hardware, software, and accessories. The company has been ranked as the 14th best global brand by Interbrand and is the 38th largest company on the Fortune 500 list of U.S. companies. But even though the disputed domain name in this case, IBMHistory.com, contains the word history, it was registered without IBM's authorization and was used in connection with a website that contained anything but information about the company's history. Instead, here's a screenshot of just part of the homepage of the website, a flashy mix of graphics and text related to such things as interest-free loans. And according to the UDRP decision, the IBMHistory.com website contained links to pornographic and gambling sites. So it's no surprise that IBM filed a UDRP complaint at WIPO to get the domain name transferred away from the cybersquatter and to it, which is exactly what happened. On the merits of the case, this was not a difficult decision, with the UDRP panelists finding that IBM had established the three elements required in every UDRP case. First, the domain name was confusingly similar to the IBM trademark because it contained the trademark in its entirety. Second, the registrant of the domain name had no rights or legitimate interest in it because it did not even reply to IBM's arguments. And third, the domain name was registered and used in bad faith because it would be inconceivable that the registrant was unaware of the widespread reputation of the IBM trademark when it registered the domain name and, among other things, associating the domain name with a pornographic website disrupts IBM's business. But although the decision was unremarkable on the substance, the reason I'm talking about it today is because of an important procedural issue, the issue that relates to the language of the UDRP proceeding itself. So here's the background. The UDRP rules say that the language of the administrative proceeding shall be the language of the registration agreement, subject to the authority of the panel to determine otherwise, having regard to the circumstances of the administrative proceeding. In other words, unlike in some other domain name dispute policies, such as the URS, or Uniform Rapid Suspension System, which applies to the new GTLDs, and Nominet's DRS, which applies to the .UK country code, each of which specifically states that the proceedings shall be conducted in English, the language of a UDRP case is often dependent on the language of the registration agreement. And since registrars are located all around the world, many registration agreements are in languages other than English. And that's exactly what happened in the IBMHistory.com case. The registrar there was a company called Pocket Domain, also known as XZ.com, which appears to be based in China and has a registration agreement in Chinese. But IBM filed its UDRP complaint in English and requested that the UDRP proceeding be conducted in English. So the issue was whether the panel should accept the request for English or require that it be conducted in Chinese. Fortunately, of course, this is not the first UDRP case to address this issue. So the panel had plenty of precedent to draw on in deciding how to proceed. And ultimately, here's what the panel wrote. On the record, respondent appears to be a Chinese resident and is thus presumably not a native English speaker. However, considering the following, the panel has decided that English should be the language of the proceeding. A. The disputed domain name includes Latin letters, IBM, and particularly the English word, history, rather than Chinese script. B. The disputed domain name resolves to a website which contains both Chinese and English content. C. The center has notified respondent in English and Chinese of the language of the proceeding and the complaint, and respondent has indicated no objection to complainant's request that English be the language of the proceeding. D. The center informed the parties in English and Chinese that it would accept a response in either English or Chinese, and the panel would have accepted a response in either English or Chinese, but none was filed. And E. Complainant is a company from the USA, and complainant will be spared the burden of working in Chinese as the language of the proceeding. Accordingly, the panel finds the choice of English as the language of the present proceeding is fair to both parties and is not prejudicial to either one of the parties in its ability to articulate the arguments for this case. So while this turned out well for IBM, not all trademark owners get their language of choice because the facts of different cases will vary and not all of the factors present in the IBMHistory.com case will apply. And sometimes other factors may come into play, such as if there are prior UDRP cases in which the registrant has been involved, or if the registrant has communicated with the trademark owner prior to the case being filed. Which is why when I file UDRP complaints for my clients, I always check first to see what the language of the registration agreement is, and if it's not English, the only language that I can speak, then I will evaluate before filing a UDRP complaint whether I can make a strong and credible argument that the case should still proceed in English. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.